And then you can just let me know when I should start. Good afternoon, everybody. Welcome, law clerks. I know we've got clerks here from all over the state, so I'm glad that you were able to join us today. We have Shannon Smith with us, and she's going to talk to us about the ICWA. Shannon graduated from the U of M Law School with honors in 1999. She clerked for Judge Robert Blazer and joined the ICWA Law Center in 2000. She has represented hundreds of families in ICWA proceedings, and she has been the executive director of the ICWA Law Center since 2005. So she's got a lot of great information for you today. I did send the slides to you last week. If for some reason you don't have them and you need them again, let me know and I can send them again. Since we're doing a webinar, just to let you know, if you have questions, to use the chat feature on the webinar, and then we'll be monitoring that and we'll pass those questions along to Shannon. So I'm going to turn this over to Shannon.
Good afternoon. Thank you for joining us today. And as Liz indicated, I welcome questions as we go. I know when you have the opportunity to clerk, you have the opportunity to see and learn a lot about different cases and different laws. Really, my introduction to the Indian Child Welfare Act was first at law school, but then really seeing the practical implication was while clerking. I think clerking provides great insight in regards to how laws impact individuals. Today, my hope is to walk you through the Indian Child Welfare Act in a way that you will have a general sense of all the requirements and mandates of the Indian Child Welfare Act. The Indian Child Welfare Act was passed in 1978, and it's unique in that it's a federal statute that has implications in state court proceedings and impacts state court proceedings throughout the country. In regards to resources that, legal resources that really impact how the Indian Child Welfare Act needs to be carried out, understanding the mandates, it's really important to, first of all, read the statute, as I know that everyone learns in law school. The statute itself is not that long, and as we go through the webinar today, we will walk through every section, or at least touch on every section of the Indian Child Welfare Act. The Indian Child Welfare Act is found at 25 USC 1901. And currently, there are not any federal regulations that inform how the Indian Child Welfare Act should be carried out. However, there are the Bureau of Indian Affairs guidelines that were first passed in 1979, and then just in February of 2015, new guidelines were issued that really explain how to best carry out the Indian Child Welfare Act. In March of 2015, the BIA issued proposed regulations that would be legally enforceable. Those regulations currently are still in the proposed state. However, there is indication that those regulations may be published at any time. Other very important resources for understanding how to implement and carry out the Indian Child Welfare Act are found in the Minnesota Rules of Juvenile Protection Procedure. There's a Minnesota statute. The federal law lays out minimum federal standards, but states are in a position where they can provide greater protection, and that's found at the Minnesota Indian Family Preservation Act, and then, as I indicated, the Rules of Juvenile Protection Procedure. There is also the Tribal State Agreement, which is really a unique document and agreement specific to Minnesota that is really the result of the Minnesota Department of Human Services and all 11 tribes that are geographically located in Minnesota coming together and deciding how they wanted Indian child welfare matters to be carried out in the state. The Tribal State Agreement was amended in 2007, and that's the most current document. There is also documentation and bulletins from the Minnesota Department of Human Services in regards to how ICWA should be carried out. ICWA was passed, as I indicated, in 1978, and really the immediate precursors to the Indian Child Welfare Act was a period of history where Indian children were being taken from their families. And the idea prior to the passage of the Indian Child Welfare Act was to use social constructs or social ideas such as schools or adoption to take Indian children from their family and basically to culture them. And the idea was that if you removed Indian children from their culture, from places where they could no longer practice their spiritual or religious practices, where they could no longer speak their language, where their hair was cut and they were forced to dress in certain ways, that really what would happen is you would kill the Indian in order to save the child. And these were the policies that were the precursors to the Indian Child Welfare Act. This idea that somehow Indian children would be better if they were not with their family. A couple of different kind of social constructs or ideas that were used in order to do this were the boarding schools, so where children as young as 5 or 6 years of age were taken from their families and placed in schools many miles from their home and basically removed from everything they knew in order to culture them. Oftentimes these schools were horrible failures. What we know now is the incidence of sexual abuse, physical abuse were staggering, that oftentimes these children were not being taught to read or to write, but really they were taught to be laborers. Also, another area that was used to remove children from their homes was adoption. For example, when the Indian Child Welfare Act was passed in 1978, 1 in 4 children Indian children under the age of 1 in Minnesota was being placed in an adoptive home. In 1978, tribes and the federal government came together in a recognition that these policies had horribly failed, that children, that families, that tribes were negatively being impacted by these practices, and that they were not in a position to move forward in a good way unless something drastically changed. And that led us up to the passage of the Indian Child Welfare Act. The passage of the Indian Child Welfare Act recognized that there was a fundamental connection between Indian children, their families, and their tribes, and that this connection was something that was to be valued and something that needed to be protected. There was an understanding in the passage of the Indian Child Welfare Act that tribes as sovereign nations had a vested interest in the future of their tribes, and that the most vital resource in the future of their tribes was their children, so that this was something that needed to be protected. It was understood at this time in the passage of ICWA that ICWA proceedings had to reflect the unique perspective of Indian families, and that while an effective and responsive child protection system was needed, that it had to be based on tribal values and the connection of tribal values to their children. Walking through the Indian Child Welfare Act, the first provision of the Indian Child Welfare Act is Section 1901, and it gives the legislative or congressional authority for the passage of the Indian Child Welfare Act, recognizes that Congress had plenary power over Indian affairs. It recognized that the integrity of tribes and their children was fundamental, and that it was something that the federal government had to protect. It recognized that there was a need for the law because of the alarmingly high percentage of Indian families that were being broken up, and also recognized that states had often failed to recognize the tribal relationship, and in fact that they had inserted their own values and ideas in regards to what Indian communities and families should look like. Section 1902 of ICWA gives a very clear policy in regards to why the Indian Child Welfare Act is needed. It is a policy of the nation to protect the best interests of Indian children. The idea that promoting the stability and security of Indian tribes and families by the establishment of minimal federal standards for the removal of children was needed. And that the families, that if children were removed, that they should be placed in homes that reflect the unique values of Indian culture. One of the most significant pieces of this policy statement as far as practice today is the idea that this is a minimum federal standard, that if in fact states want to enact legislation or have laws that protect children, Indian children in a greater way, that those in fact need to be followed, but that at a very minimum, the mandates of the Indian Child Welfare Act have to be put in effect. This is often sometimes people say, well, we're almost there, we almost meet the ICWA standards, and actually ICWA should be the floor and not a ceiling. Section 1903 is a definition section, and I'm not going to go through all the definitions, but I think one of the things that is very critical, and one of the questions that comes up frequently is how do you know when ICWA applies? And there's really two different questions that you should ask to determine whether or not ICWA applies. And the first question is whether or not you have a child custody proceeding. A child custody proceeding is what the federal statute uses, and sometimes that causes confusion because it's a federal statute that is being mandated to in regards to state court proceedings. So we don't, in Minnesota, you won't see child custody proceeding, but you will see things like foster care placement, termination of parental rights, pre-adoption placement, adoptive placement, or third-party custody proceedings. ICWA applies in all of those proceedings. Really the thing that you want to think about in regards to whether or not you have a child custody proceeding is whether or not a parent can ask that a child be returned to them upon demand. So if you have a situation where the parent can say, yeah, I want my child to come home today, and that legally can be enforced, then that you may want to question whether or not it's really a child custody proceeding. It may just be some kind of voluntary arrangement that really doesn't impact the courts. However, if it's a situation where the county or the state court is saying this child is going to be ordered out of home for any period of time, there's a good indication that that will be a child custody proceeding for ICWA purposes and that it will apply. ICWA is very clear that it does not apply in divorce proceedings. So it does not apply in situations where you have a custody dispute between biological mom and biological dad, unless there's a third party involved, for example, a county involved, trying to dictate where that placement is going to be. ICWA also does not apply in delinquency proceedings. So if you have a situation where a child is, there's a petition, a delinquency petition for a child, and it does not involve a status offense, then ICWA does not apply. ICWA will apply in situations where there's a truancy or a runaway situation. The second question to determine whether or not ICWA applies is a determination of whether or not an Indian child is involved. An Indian child is either a member of an Indian tribe or eligible for membership in an Indian tribe. The only way to make that determination is through the tribe. The tribe gets to determine who is a member of their tribe and who may be eligible either for enrollment or for membership. And there is a distinction, but that information is going to come specifically from the tribe. So the tribe has to receive notice in order to make that determination of whether or not an Indian child is involved in the proceedings. The federal statute indicates for an Indian child that the parent must be an enrolled member of the tribe. The Minnesota Indian Family Preservation Act takes out that requirement, so really the Indian child definition applies specifically to that child, and so that information needs to be provided to the tribe in order for the tribe to make a determination of whether or not the child is an Indian child. If a tribe indicates that a child is enrolled as a member of an Indian tribe or eligible for membership, then the child is deemed an Indian child. If the tribe says, yes, the child is a member of an Indian tribe, however, we do not wish to intervene in this proceedings, that does not impact the ICWA status. It just means that the tribe is not asserting their rights as a party. So really the only two questions you need to ask in regards to whether or not an ICWA proceeding, if you have an ICWA proceeding, is first the question, do you have a child custody proceeding? And then the second question, do you have an Indian child? As far as the sections of ICWA, the next section of ICWA is section 1911. And 1911 is really the jurisdictional basis of ICWA. This is an area that a lot of times causes some confusion and some, I think, anxiety in regards to how this is going to impact a case. It's a recognition that tribes are sovereign nations that predate the establishment of the United States, and that Indian tribal jurisdiction is the preferred jurisdiction in Indian child custody proceedings. Tribes may have exclusive jurisdiction. There may be situations where state court proceedings can be transferred to tribal court, and also recognizes that in state court proceedings, Indian tribes have a right to be a party. In some states, there's actually a requirement that Indian tribes intervene as a matter of right. In Minnesota, we recognize that just as a matter of law, that Indian tribes are a party. So if you have an ICWA proceeding, tribes do not need to intervene. They will be a party by matter of our statute. In regards to transfer proceedings, there are several tribes geographically located in Minnesota that have tribal courts that are very active in Indian child welfare matters. And so it may be a situation where there's a state court proceeding and a tribe will come in and ask that the proceeding be transferred to tribal court. If that occurs, the presumption is that that in fact should happen. There are some exceptions. Either biological parent has a right to veto that transfer to tribal court if they choose. The other parties may also object to the transfer to tribal court and have the burden of proving that it should stay in state court, and would have to prove through good cause that in fact the proceeding should stay in state court. In the good cause analysis, if a party indicates that they want a proceeding to stay in state court because they want a certain outcome, that is something that is not proper to be before the court. There's a Supreme Court case in regards to the jurisdictions, the Mississippi Band of Choctaw Indians versus Holyfield, and talks exactly about that. That it's not an issue as to what the decision is going to be, but whether who gets to make the decision in regards to the best interests of Indian children.
Can I ask a question?
Yes.
So either parent can veto it, or just the native parent?
Either parent can veto. So if there's a situation where, let's say that the tribe motions for a transfer to tribal court, the county is agreeable to it, the children are agreeable, and guardian ad litem are all agreeable that this is what is best. If either parent says no, then it stays in tribal court, or excuse me, in state court. Oftentimes there may be a reason where parents, regardless if they are a member of that tribe or not, may want it to transfer to tribal court. Tribal court, the Indian Child Welfare Act does not apply in tribal court, because tribes as sovereign nations have the ability to write their own code. And so sometimes there's the outcome or the possibility of different permanency dispositions, or the possibility of having different resources may open up in tribal court. So for example, the White Earth Band does what's called customary adoptions. So if a case is transferred to White Earth Tribal Court, it may be a situation where a termination of parental rights is no longer being talked about. They do have mechanisms for permanency, but it could be, for example, a customary adoption. The idea of a customary adoption is that they would not terminate the parental rights of the biological parents. They would suspend them and then basically creating two families for the child. So there would be a family where the child would need to be in order to be safe, and it may be a family member. At the same time, there's an assumption that the parents would have a right to have contact as long as it was safe. There would be an assumption that if something were to happen to the adoptive family, that the parents would be notified to see what their situation was at the time. So a lot of times there's an incentive or there's a desire of parents to have a matter transferred to tribal court because it may open up more culturally specific or relevant dispositions. But certainly if for whatever reason they want the proceeding to stay in state court, either parent has that veto power to object. Section 1912, I always say, is the very practical aspect of ICWA and probably the area of the Indian Child Welfare Act in state court that there's the most litigation about. It lays out kind of what an ICWA proceeding is going to look like in state court. The first piece is notice, being very clear that the parent, the Indian custodian, and Indian child's tribe has a right to notice. The other Another provision that is very significant in Minnesota right now is the appointment of counsel for the parents. If indigent, the parent or Indian custodian has a right to counsel, and for a child, if it's in the child's best interest. So in an Indian Child Welfare Act proceeding, both mom and dad should have counsel if they cannot pay for it and if it's something that they want. So any kind of situation where I know some counties are appointing counsel just for one parent, or they're appointing counsel to represent both parents at the same time, and so that each parent doesn't have their individual counsel, it certainly runs afoul of the mandates of the Indian Child Welfare Act. So there's a very clear indication that in ICWA proceedings, counsel is a right. Section 1912C, examination of reports. This is really the discovery provision, indicating that parents, that tribes, they have a right to examine and to receive discovery in these proceedings. Section 1912D is the active efforts provision. So this is a provision that mandates that in ICWA proceedings, active efforts must be provided in order to keep the family together when at all possible. Active efforts is a standard that is higher than reasonable efforts. So in a non-ICWA proceeding, parents have a right in most proceedings for reasonable effort. Active efforts are required in Indian Child Welfare Act proceedings. Active efforts has not been defined in Minnesota until just this past legislative session. There was an amendment to the Minnesota Indian Family Preservation Act that specifically includes a definition of active efforts. So active efforts requires that the local social service agency provides services to the family from the time that a case comes in or a time that the family is first identified all the way until the case is closed. There is no provision in Minnesota statute or in the Indian Child Welfare Act that allows a county to be relieved of active efforts. So oftentimes how this is described is that active efforts are really required from the time of contact with the family to the time a case is closed. So contact to closure, active efforts are required throughout the entirety of the proceeding. Active efforts can mean, are basically what we know, and now we have a definition of it, are more intense than reasonable effort. So for example, if you have a situation where a social worker or local social service agency is providing referrals in a case that is non-ICWA, and they're providing the family with a number and saying you need to call this agency and set up a parenting assessment or parenting capacity assessment in the next month. In an ICWA case, it may mean that that agency actually needs to take that family, set up the appointment, provide the family with transportation, and make sure that they can access those services. So active efforts is something above and beyond what reasonable efforts are. The Casey Family Foundation has actually, in an amicus to the Supreme Court, indicated that active efforts are really the gold standard of social work, that is really something that we should be looking at for all families who are involved in child protection proceedings, that it's really that active engagement, that relationship building that really has an impact in regards to how families are able to navigate the child protection system. ICWA 1912E is a foster care placement order, evidence, and determination of damages to the child. There's a requirement when an Indian child is placed out of the home that a qualified expert witness supports that out-of-home placement. And that qualified expert witness requirement comes from 1912E and 1912F. In 1912E, is the foster care placement, and then 1912F is specific to a termination of parental rights. Significantly, 1912F, dealing with the termination of parental rights, provides a higher standard, legal standard, that needs to be proved when there's a termination of parental rights involving an Indian child. And the standard is raised from clear and convincing evidence, which is our state standard, to beyond a reasonable doubt. And that heightened legal standard comes from 1912F. 1912F also requires that whenever there is a termination of parental rights, that a qualified expert witness is required to support the child remaining out of the home. A qualified expert witness is distinct from an expert witness, as we think about in many legal proceedings, and the qualified expert witness definition is also found in the Minnesota Family Indian Preservation Act. I'm going to go back to the 1912 active efforts for just a minute. This is a list that indicates some of the things that were thought of as the new legislation defining active efforts was put into place. So things that you want to think about when you're talking about active efforts, when you're talking about qualified expert witness, is really getting guidance from the Indian child's tribe on family structure. And this is both for active efforts and then also for the qualified expert witness. The qualified expert witness, if there's a qualified expert witness that is designated by the Indian child's tribe, they are not subject to disqualification. So what that means is that they are going to be qualified as an expert witness. Now, their testimony certainly is subject to cross-examination as to the weight of their evidence, but their actual designation as a qualified expert witness is not subject to challenge. One of the things that they can often provide guidance on is the active efforts piece. So what is that Indian child's tribe, specific to the Indian child? What is their family structure? Are there barriers that are preventing the family from engaging in services? So for example, kind of going back to the first piece, if a family is told you need to get a parent capacity assessment, that it's not just enough to say that you're going to get that assessment, but really talking about do you have transportation? Would it help if in fact the social worker did go with you? Or if you're going to be provided public transportation, is the location of that assessment really a place that you can access? Are there other things that are preventing families from engaging in services? The ICWA, through active efforts, qualified witnesses, and placement preferences also recognizes the importance of extended family and recognizing that family structure may be different depending on the tribe. And so the services to extended family members to allow them to be a part of the process, to be a placement option, or to be a resource for the family is consistent with providing active efforts. ICWA Section 1913 applies specifically to voluntary proceedings. ICWA does apply in voluntary proceedings when there's a voluntary foster care proceeding or a voluntary termination of parental rights. And this is significant. Oftentimes, these are the kind of stories that you hear where there's been a situation, in the media where there's been a violation of ICWA and they become the very highly publicized. Media often becomes involved and wondering what went wrong. And often those situations center around ICWA Section 1913. And I've had the opportunity to work with many families and many moms who have made a decision to voluntarily terminate their rights or to place a child for adoption. And I often say that ICWA 1913 is exactly what we need, because what it does is gives assurance that when a parent, but if it be a mom, is making a decision, and most important decision of their life, that they're protected and able to make a decision that is truly voluntary and something that we can assure that they understand. I often feel really squirmish and sick when I hear people say, okay, let's make adoptions easier. And when you make adoptions easier, not that adoptions cannot, that sometimes adoptions are a wonderful, beautiful thing, we don't necessarily want to make it easy. We want to make sure that we're getting it right. And so ICWA Section 1913 allows us to do that. What ICWA 1913 says is that in order for a parent to consent to the voluntary termination of parental rights, that they need to be before a judge so that they can come in and make sure that they understand their rights, understand the implications of what they're doing, and that the judge can certify that. It indicates that this decision or this consent cannot be given prior to or within 10 days of the birth of the child. One of the criticisms of the Indian Child Welfare Act is the enforceability of it. As has been indicated, the Indian Child Welfare Act was passed in 1978. And it was really, when it was first passed and implemented, it was something that was looked at as great promise for tribes and something that people were very hopeful would have a significant impact in regards to strengthening tribes, strengthening the connections of Indian children to their families and to their tribes, and really assuring that the best interests of Indian children was met. Unfortunately, one of the things that is still very clear is that we have a long ways to go. While there's been a lot of really positive things in Minnesota, Minnesota is the worst in the nation, or at least among the worst in the nation, in regards to the disparities in the number of Indian children that are placed out of the home. In Minnesota, the number is more than 15 times, that an Indian child is more than 15 times more likely to be placed out of the home than a non-Indian child. So the disparities are staggering, and it's something that I know the state, tribes, individuals who work in this area are all very concerned about. The numbers, the 15 times more likely, are numbers that are coming from the Minnesota Department of Human Services. So there is still significant and very important work left to be done. The ICWA, as far as enforcement mechanisms, one of the things that it does provide is Section 1914 and a petition to invalidate. What 1914 indicates is that any child who is subject to an action, a parent or an Indian custodian whose custody a child was removed, or the Indian child's tribe, may petition the court to invalidate the proceedings. And the provisions that are applicable to the petition to invalidate is if there was a violation of Section 1911. So if you recall, that is the jurisdictional issue, whether or not a tribe has exclusive jurisdiction, whether or not a case should be transferred to tribal court, and the tribe's right to be a party in the proceeding. Section 1912, which is the provisions of notice, the provisions of right to counsel, the provisions of discovery, active efforts, and then the standards for foster care placement, including the qualified expert witness, and then the standard for termination of parental right beyond a reasonable doubt, including a qualified expert witness. And then Section 1913, which are the provisions we just went over, which are the voluntary provisions, that if in fact a parent is going to give voluntary consent to the termination of the parental rights, that has to be done in front of a judge. If there's a violation of any of those provisions, that there is a right to go to the court, either the court that first heard the matter or a court of competent jurisdiction, to invalidate the proceedings. So this is an area that allows for some remedy. Oftentimes it's, I think, underused and not really understood in exactly what needs to happen if in fact there's been a violation of these sections 1911, 1912, or 1913. The Minnesota Rules of Juvenile Protection Procedure also give some procedural guidelines in regards to how to file a petition to invalidate.
Can I ask if there's a timeline, like 10 years, like 10 years after, 1 year after?
Yeah. So there's a question in regards to the timeline for a petition to invalidate, and there's not a timeline that's specific in ICWA. There is some case law around the country that basically imposes statute of limitations to petition to invalidate. In Minnesota, that has not been litigated at this point, so I would say that there's not a timeline. However, I think it's really important to recognize that all of these provisions, 1911, 1912, and 1913, that if the provisions of ICWA are followed, then there hopefully will never be a need to do a petition to invalidate. So that's why you want to make sure that when you have an ICWA proceeding, that these provisions, these federal mandates are being followed, so that you're not in a situation in the future where families are negatively impacted because someone chose not to follow the federal statute. And so that's something that often it's really important to understand, and not to, oftentimes we'll hear people, well, we didn't follow it because we didn't understand, or we didn't want to know, or it was making things too complicated, and it was, we didn't want to bring mom before a judge. And it's really important that the provisions are followed, so that you are not opening up a family to possible implications of a petition to invalidate sooner. The Supreme Court in the Mississippi Band of Choctaw Indians versus Holyfield touches a little bit on this, and it wasn't specifically a petition to invalidate, but they talk about the fact that you can't use the passage of time to excuse you from a violation of ICWA. So basically, if you choose not to follow ICWA, and because it's such an important federal mandates for Indian children and for tribes, then you can't use the passage of time saying, okay, the child is now bonded to a family, and we chose not to follow ICWA, but now we have a situation where a child is bonded to a family, and the Supreme Court was very clear that you can't use that as a basis for not doing the right thing. And so it was very clear that these mandates are very important to be followed, and the reason why they're important to be followed is because they ensure the best interests of Indian children, and they ensure the best interests of Indian tribes. Section 1915 of the Indian Child Welfare Act focuses on the placement of Indian children in specific order of placement preferences. So when you're making a determination of where a child should be placed, ICWA lays out very specific placement preferences of what should be followed. And there's two different provisions. There's the Section A is the adoptive placement, and then Section B is the foster care placement. They're a little bit different, and I think it reflects the idea that the implications for a foster care placement are very different than the implications for an adoptive placement in regards to that child's connection to their family and to their tribe. And so the placement preferences indicate that there's a preference and they should be followed in descending order. So the first preference is a member of the Indian child's extended family. If there is not someone available from the Indian child's extended family, then a foster home licensed, approved, or specified by the Indian child's tribe. An Indian foster home licensed or approved by an authorized non-Indian licensing authority, or an institution for children approved by an Indian tribe. So those are the foster care placement preferences. And then the adoptive placement preferences indicate that a child should be placed with a member of the child's extended family if possible, other members of the Indian child's tribe, or other Indian families. And those placement preferences reflect that if a child is in an adoptive placement, that is going to be a situation that lasts forever, and so those connections are really important. Oftentimes, if tribes are involved in the proceedings, they will be very specific in regards to indicating what they believe is best as far as the adoptive placement preferences. It is also possible for tribes, consistent with ICWA, to determine alternative or different placement preferences. And if the tribe does that, then that is something that can be taken into consideration as well. A violation of Section 1915 is not a basis for a 1914 action. So when you go back to the 1914 petition to invalidate, the petition to invalidate specifically includes sections 1911, 1912, and 1913, and does not include Section 1915. In the more recent Supreme Court decision that addressed the Indian Child Welfare Act, in the matter of the adoptive couple, the placement preferences were addressed. It was not something that was actually in the holding of the case, but they are discussed at some length. And one of the things that the Supreme Court indicates in that decision is that in order for the the placement preferences to be considered in an adoptive proceeding, that if someone wants to be considered as an adoptive resource for the child, that they affirmatively need to present that to the court. So one of the things that they talk about, that situation involved a dad and then a family who, through the mom, wanted to adopt a child. And they actually indicate in that decision that if dad had filed an adoptive a petition to adopt his child, that he may have been in a different position, which seems a little absurd, filing a petition to adopt your own child. But it does indicate, and one of the things that we have seen happening in Minnesota is that families who have stepped forward and want to be considered as an adoptive resource have affirmatively brought that before the court by filing a petition. 1916 is a specific provision of ICWA that talks about what happens if a final decree of adoption is vacated or adoptive parents voluntarily agree to termination of the child. And so there's actually a provision in ICWA which is somewhat similar to the cultural values in a customary adoption out of White Earth, is that if for any reason rights of a parent are terminated and then the child is adopted and that adoption is disrupted or that adoption fails, that the parents should have a right to petition for return of custody. Now, certainly doesn't mean that it's an automatic, but that if they are in a different situation than they were at the time of termination of parental rights, that they may actually be able to come back into the court and ask that a child be returned. Again, it's under very specific circumstances. So if an adoption has been vacated or there's been a voluntary termination of rights of an adoptive family. (1917) indicates that for children who are adopted, Indian children who are adopted and then turn 18, and are subject of an adoptive placement, that they should and have a right to have information in regards to their tribal affiliation. And so that information should be provided to them regardless of what the status of the adoption, if it's a closed adoption or whatever the status of that they have a right to know. And for most tribes, their tribal enrollment will not be impacted by the fact that they have been adopted. So there's a right for them to have that information, and very important for them to know from an identity perspective, but then also in regards to what they may be able to access from their tribal community, that information needs to be provided to them.
We do have a question through chat. Could you discuss the implications of the Baby Veronica case on the requirement of tribal membership?
Yes. So the question was in regards to the Baby Veronica case and its implications on tribal enrollment or membership. The Baby Veronica case, the impact on tribal enrollment, there really was not any impact, I guess, is kind of the easiest answer. If you've read the opinion, the very first paragraph indicates that the child, and I don't remember the exact number, 436 Cherokee or whatever's in the opinion, and really, I think it was very disheartening and unfortunate that was in the Supreme Court opinion. In regards to the Indian Child Welfare Act, really the kind of the fundamental question is whether or not the child is a member or eligible for membership in a tribe. And the tribe as a sovereign nation gets to determine who are citizens of their nation. In the Baby Veronica case, it was very clear and not challenged throughout the case that Veronica was a citizen of the Cherokee Nation, and that is why the Indian Child Welfare Act applied. In regards to what her blood quantum or whatever numbers the Supreme Court indicated in there was, from my perspective, really irrelevant and not something that had any impact in regards to the Supreme Court's decision at all. One of the things that tribes as sovereign nations, every tribe has different determinations of what is required to be a member of that tribe or what is required to be a citizen of that tribe. So just, for example, if you thought of, I'm a U.S. citizen, I would never say, well, I'm 1/680 U.S. citizen or I'm part U.S. citizen. Certainly there's situations where someone may have dual citizenship, but you would never divide it out the way that the Supreme Court did in the Baby Veronica decision. So it's in there, and I think it's caused some, maybe some confusion or caused some idea that was important, but it did not go into, or it did not impact the decision that they made in any way. The Baby Veronica case was based on the idea that ICWA did apply, that Veronica was a citizen of the Cherokee Nation, and it was really up to the Cherokee Nation to make that determination of her being an Indian child. I'm going to skip over 1918. 1918 is a section in regards to resumption of jurisdiction over child custody proceedings. Certainly that has had an impact in Minnesota, but it's something that it involves tribal court jurisdiction. 1919 indicates that tribes and states can come up with agreements in regards to how to best carry out Indian child custody proceedings in the state. And Minnesota has really been recognized as a leader in the nation in this area in the development of the Tribal State Agreement. The Tribal State Agreement came into existence in 1998 and then was amended in 2007. The development of and the passage of the Tribal State Agreement took hours and years of negotiation between all 11 tribes in the state of Minnesota, and there was a lot of time and energy and really collaboration that went into the passage of the Tribal State Agreement. The Tribal State Agreement really laid the framework for the new amendments to the Minnesota Indian Family Preservation Act. So the Minnesota Indian Family Preservation Act had significant changes this past legislative session that went into effect just this past summer. And they included things like a definition of active efforts. They included a definition of the best interests of Indian children. They included a definition and explanation of qualified expert witness. And really the basis of all these amendments to the Minnesota Indian Family Preservation Act can be found in the agreements between the state and all 11 tribes in the Tribal State Agreement. So 1919 of the Indian Child Welfare Act is really the basis for why these agreements are so important. And the agreement between states and Indian tribes, when you think about really kind of the implications of having the state of Minnesota and all 11 tribes coming together to agree on language, is really significant. And so it was very clear that there was a real commitment and desire to collaborate because of what was going on in Indian child welfare proceedings in the state, and a desire to make them better and a desire to ensure the best interests of Indian children were being met. The underlying premise was that things have to get better in Minnesota because we don't want to continue to be the very last in the nation in regards to the disparities between the number of Indian children being placed out of the home and the number of non-Indian children being placed out of the home. And so in February of 2007, finally after several years of negotiation, an agreement was signed. And the purpose of the agreement was determined to protect the long-term best interest as defined by the tribes of Indian children and their families by maintaining the integrity of the tribal family, extended family, and the child's tribal relationship. The best interests of Indian children are inherently tied to the concept of belonging. Belonging can only be realized for Indian children by the recognition of the values and ways of life of the child's tribe and support of the strengths inherent in the social and cultural standards of tribal family systems. Family preservation shall be the intended purpose and outcome of these efforts. One of the things that I heard as these negotiations were going on from several different tribal representatives, that they often felt that state court proceedings, when they were talking about the best interests of children, really were talking about a snapshot in time. So they were looking at the child maybe at age 12 age 4 when a decision was being made, and they were saying, okay, great, this child is in a home that is meeting their needs right now. And that there was a real failure to look at the child, and as they described it, we don't need a snapshot in time, we really need a video or kind of a moving camera of what that child is going to look like when that child is 8 or that child is 12 or the child is 16, and then that child into adulthood. And really recognizing that for many Indian children, that identity is something that was not being taken into consideration. And so even if we were making a decision or a decision was being made at the time a child was 4, that it was often very short-sighted and not really taking into consideration what that child's experience was going to be like. And also recognizing that for Indian communities, tribal communities, that often the ideas and the experience of historical trauma, generational trauma, and individual trauma were things that were very real, and that by just looking at that snapshot in time, we're not taking that into consideration. The Tribal State Agreement recognized that for Indian people, they understand that the children are the future of their tribes and vital to their very existence, a recognition that an Indian child is sacred and close to the Creator. And this is language that was specifically incorporated into the Tribal State Agreement and language that was approved by the 11 tribes in the Minnesota Department of Human Services on behalf of the state. 1921 gets us back to the idea that ICWA is really a floor. ICWA is not a ceiling, but it is a floor that the minimally needs to be implemented in order to protect the rights of parents and Indian custodians and Indian children. ICWA is only the beginning and does not dictate an answer, but rather gives us a framework to reach it. And the idea is that that framework understands that tribes as sovereign nations have a vested interest in the outcome or the future of their children. 1922 provides us with the emergency removal or placement of an Indian child, indicating that nothing in ICWA shall be construed. If emergency removal of an Indian child is needed, that can happen, but there's certain parameters and certain guidelines that must be followed. And then the conclusion, and again, this is just going back to the language in the Minnesota Tribal State Agreement, that it is recognizing the best interests of an Indian child are inherently tied to the concept of belonging. The Minnesota Indian Family Preservation Act has incorporated some of this language in a specific definition of the best interests of Indian children, and recognizes that the best interest of Indian children is a distinct standard from the best interest of children that have that is found in other places in Minnesota law. I think that is it, unless anyone has any questions.
One more slide.
Oh, sorry. I was speeding ahead thinking our time was up. In regards to future implications, certainly ICWA is an area of law that is, there is a lot happening in Minnesota right now. And so and hopefully a lot happening and very committed collaboration to make sure that we are able to address the disparities and to help change that for Indian children. Certainly foster care is sometimes necessary, but it's also recognized that being in foster care itself is a situation that adds to trauma for children. There is federal litigation currently going on, a class action lawsuit in South Dakota. One of the challenges in South Dakota was the idea that parents did not have a meaningful opportunity to be heard at the emergency hearings. So akin to our emergency protective care hearings, or EPC hearings that we have in Minnesota, there was concern that sometimes those hearings were lasting 45 seconds and that decisions were being made about placement of children. And so there's been, so far, the challenges in South Dakota have indicated that those are federal violations of parents' rights. And so one of the things that I think is very important as we move forward in Minnesota is recognizing the importance of parents having a meaningful right to be heard and a meaningful right to counsel at those hearings. We have the Supreme Court decision, the adopted couple versus baby girl, and the implications that that may have. There was no constitutional challenges. The court did not address any of the constitutional issues in regards to ICWA in this decision, but did address issues involving private adoptions and the implications that that may have. There is also a federal lawsuit going on right now in Arizona, the Goldwater Institute, and that does involve some challenges, but right now there's no decisions on that. I think the other really important thing that will happen, I believe any day now, is the publication of the regulations for the Indian Child Welfare Act. And there is some indication that there may be some more enforcement mechanisms that are built into the regulations or outlined in the regulations. So that's something to be looking for as well.
We do have one question from chat. What resources are available to law clerks with ICWA issues? Outside of Westlaw research, is there a place and manner to get questions answered?
At the ICWA Law Center, we would be happy to answer any questions. We do have a website that has the Indian Child Welfare Act on it. It also has the Tribal State Agreement and the BIA guidelines. If there are questions that we can answer or questions we are happy to either answer those questions or make referrals. There are many people who are truly experts in this in Indian Child Welfare Act that are recognized on a national level that actually are practicing in Minnesota. So if you have questions, we would be happy to get you connected with people that hopefully could answer your questions or at least provide you with resources. But definitely there is a wealth of knowledge in Minnesota of people that have been working in this area for a long time.
Thank you.
Thank you.
Do you stop recording?